So my brothers and sisters, I'm going to conclude by telling you this. You know, civil rights is something that the Constitution guaranteed. It is ours. It is not something that is made up. It's real. It's tangible. You can feel it. But if you think about it, from the days of slavery to present, no matter what it is, any time that is right, there will be a struggle. So when disappointment comes, understand what Job went through. See, I've heard people say, I've had a Job moment. But I say, I doubt it. Because you see, to have a Job moment, what you got to do? You got to lose everything. All your children is going to be dead. All your possessions going to be taken. All your land, everything. Now think about it. Look what they're trying to do about foreclosure. But you ain't lost your life. You ain't lost your children. So you still ain't got to the Job moment yet. So now, but what did Job teach us? That as long as I trust God, as long as I trust Him, I know that prosperity waits for me on my next step. Bless you.
Now that we've set the table, we're ready for Attorney Misty Oaks of the Oaks Law Firm to provide for us some of the food and libation in terms of what needs to happen and how we need to go forward and how we need to remind the Attorney General, the Governor, the Governor's Office of Consumer Affairs, and all other interested parties, the banks, the robo-signers, okay, the foreclosure mills attorneys. It's a new day in Georgia. Thank God.
My name is Attorney Misty Oaks. I am the founding partner and principal member of the Oaks Firm, LLC, where the bulk of my practice right now is mortgage fraud and foreclosure defense. So every day, the firm takes in about 10 to 50 new clients every single week. So every day, day in and day out, I see the practical effects of this foreclosure crisis that's going on. And one of the more disheartening statistics that I have to report is that fraud has been found in approximately 80% of all mortgage transactions across the entire United States of America. Really over 80%, but yeah. So it is prevalent and pervasive. And I was going to get up here and do a whole diatribe on the real crisis and the underlying problems, but President Wright has so aptly and rivetingly explained many of the underlying problems. So I will just briefly cover a couple of things in terms of the real crisis and the underlying crisis. Two things happen when you sit down to sign your mortgage documents. You sign a promissory note and you sign a mortgage instrument, which is either entitled a mortgage or a security deed. The promissory note is really the be-all, end-all instrument. Whoever owns that note is the real party in interest who is entitled to collect on that debt. Now, the problem is that almost immediately after signing your mortgage, what the original mortgage company typically does is they bundle all of their mortgage instruments, their promissory notes, and they sell them as mortgage-backed securities. They sell them to big banks, investors, other mortgage companies, trusts, or loan servicers for massive profits. They either destroy the original promissory note or they ship them to foreign warehouses in China, India, and many other countries. So as a result, the homeowners have no idea who they're supposed to pay, who is entitled to collect this debt from them. They don't know the balance of their account. The mortgage companies fail to give them a true and accurate audited accounting of their accounts, so they don't even know how much they owe, and many, many other violations. So, and many other mortgage companies have engaged in predatory lending, whereby they approve a person who is making a $30,000 a year income for a $180,000 mortgage. Predatory lending at its finest, and I see it all day, every day. Many loan servicers have committed numerous violations of the Fair Debt Collection Practices Act by altering homeowners' loan numbers and account numbers. So, in essence, what happens is the homeowners have no idea what loan they're even reporting on. They don't know what loan number to put on their checks. Again, they don't know who to pay or how to pay because they don't know who the original party in interest is. Subsequently, the loan servicers who do not own the promissory note, and let me just mention one other thing. A promissory note is transferred anywhere between 16 to 42 times before it ends up with your current loan servicer, okay? And as a sidebar to this, all of these assignments are required to be recorded, and proper notice is required to be given to the homeowner. 9 times out of 10, the vast, vast, vast majority of the time, proper recordation does not take place. The homeowners, again, are not aware of however many intermediate servicers have had their hands on their mortgage instruments. They don't know, again, who to pay, okay? The loan servicers have routinely refused to talk to homeowners by putting their calls through to foreign call centers in India. They've refused to offer homeowners mortgage loan modifications, which, by the way, they are required to do if they have received any bailout money from the federal government. And then they have foreclosed with forged or fraudulent documents, which 9 times out of 10 are signed by companies, which we so aptly call robo-signers. Okay, so what happens is that in order to foreclose, they hire a company who either fraudulently forges a notary's name, or they forge dates, they forge loan numbers, and then they pass them off to effectuate these unlawful foreclosures. At the heart of this crisis is a company called Mortgage Electronic Registration Systems. This is a company, the very design of which is defective from the beginning. It is designed to get around the legal requirements of recording assignments and giving proper notice to homeowners. What they do is they trade Excel spreadsheets between mortgage companies and loan servicers. One mortgage company says, I have a $100,000 mortgage here. Who's going to buy it from me for $180,000? Who's going to buy it from me for $250,000? And they transfer Excel spreadsheets. They sell the mortgages without proper recordation, without proper notice to the homeowners, and then all of a sudden you have a foreclosure notice from a company that you never signed a contract with, who you never agreed to pay, and who you have no idea how they became involved with this transaction, okay? The vast majority of the time, MERS, Mortgage Electronic Registration Systems, is listed as a mere nominee on your mortgage transaction. That means that they do not own the original promissory note. That means that at least 90% of the time, MERS lacks the legal right to foreclose or further assign your security instruments. The courts have then been induced to perpetuate these fraudulent and unlawful foreclosures by failing to require the foreclosing parties to prove that they are the proper party in interest. They are failing to require them to produce the original promissory notes, which again have either been destroyed or in a warehouse somewhere in China. So they are not enforcing the assignment laws and the recordation laws as they should. And more prevalently, they are being somewhat biased towards pro se litigants. Pro se litigant is a litigant who does not have an attorney and represents themselves in court. So there is no uniform way that the courts are dealing with pro se litigants in particular. So there's no legal precedent that me as an attorney could look to say this is how it's been handled in the past, because they are widely just really all over the place in terms of adjudicating these foreclosure cases.